All right, it is 11:30 on the dot, so we can go ahead and get this party started. Good morning. My name is Noelle Hicks. I am a shareholder here in our Houston office at RMWBH. And today, for our first webinar of 2026, we're going to talk about introducing the new RMWBH collection process. So during this presentation, we're going to kind of go over a couple of things that you guys might already know and some tweaks that we've made to our collection process. But as usual, we're going to start off with our disclaimer that this information I present to you is the law as it exists as of January 20th, 2026. Hopefully, we are all getting accustomed to writing 2026 instead of 2025. But keep in mind that this is for educational purposes. It is not legal advice. But if you have any questions about anything that we talk about here today, make sure that you reach out to us or the attorney that represents your association. So for our agenda today, we're going to go over a couple of the collection-related laws, some of them that you'll be familiar with, and a couple of them were new from our second to last legislative session. We'll talk about our pre-litigation 209 collection process and then our pre-litigation Chapter 82 collection process. So these are going to be our in-house processes that we're going to kind of give you a sneak peek into so you can see how things sort of operate inside of our law firm. And then we'll talk about the RMWBH true flat fee and kind of explain what that means. So first off, let's talk about some of the collection related laws. A lot of these you guys are going to be familiar with because you deal with them every single day, and you're probably sick and tired of hearing about these laws, but they're important for us to kind of go over. During today's presentation, I'm not going to delve that deeply into all of them, but I will talk a little bit more about the open board meeting requirements and priority of payments. Obviously, you guys have seen or probably even heard of Regulation F. Regulation F is a federal law that comes from the FDCPA, and those are related to those sorts of entities that are actually collection agencies, which law firms that engage in the collection of assessments are technically collection agencies under that statute. So it's important for us to kind of understand what those laws are and how they relate to our collection processes, as well as, some of the things that you guys are doing on a day-to-day basis. And then for our condo associations are also subject to the FDCPA Regulation F. But then we're going to delve a little bit more deeply into Chapter 82, Section 113, and we'll talk a little bit more about liens, foreclosure, and transfer of ownership. And this is going to kind of help to understand why we do some of the things that we do in-house here at RMWBH. So first things first, there is a kind of a new update, and this was implemented again in our second to last legislative session, but it is a requirement for assessment lien notice for single family associations. So prior to this law being enacted, an association could really just go in and file a lien in the real property records, and that for the delinquency on assessments, right? And as we all know, the declaration itself creates a lien on all of the properties that are subject to the declaration or subject to enforcement of that declaration. But this is a second step that some associations choose to do. And obviously, if you have that ability in your declaration or that is allowed by your declaration, then you can file an assessment lien in the real property records where that property is located. So obviously, first and foremost, you want to check in your declaration to see if you even have the authority to do that, or if there are any other requirements by the declaration, which typically there aren't. But the property code in section 209.0094 now requires certain notice to be given to a homeowner before you can actually go and file that or record that lien in the real property records. So the first notice needs to go out to the homeowner by first class mail, to the owner's last known mailing address, or by email to the email address that's provided to the association by that owner. And that notice needs to be a 30-day notice, right? So the second notice after that 30 days has expired needs to go out by certified mail. And this actually adds an added layer of notice period. It's actually 120 days now before you can actually record a lien in the real property records. So as you can see from that last little bullet point there, an assessment lien can't be filed before the 90th day after the notice of delinquency was sent to the owner. So we have to take into account that first 30 days plus that 90 days, right? So these are some requirements that you should be aware of, that you probably had heard of, and they only apply to associations that actually record a lien in the real property records. Now, keep in mind, again, as I mentioned, this is not a requirement. It's just that if the association chooses to do this, these are the requirements that they have to adhere to. There's another prerequisite to a lawsuit that I kind of wanted to mention as well. As you all know, the association is required to hold open board meetings. And with those open board meetings, there are certain things that have to be done or have to be accomplished during an open board meeting. There are at least 15 tasks that have to be done there, and those can be found in section 209.0051. And one of the things that we really need to consider for this particular presentation is the initiation of foreclosure actions. So in 209.0051, it's very clear that the board cannot, unless it's done in an open board meeting for which prior notice was given, consider or vote on initiation of foreclosure action. So what this means, broken down, is that the association cannot initiate foreclosure actions or consider or vote on that any other time than during an open board meeting. Now, it's kind of up to interpretation what the initiation of a foreclosure action actually looks like. That could either be voting on sending it to the association's attorney, or it could mean whether or not the association is going to actually initiate a lawsuit, right? So our recommendation would be just to make sure that there are meeting minutes that reflect that the board has voted on even sending a new enforcement action or a new collection action over to the attorney to begin that process. That way, when we get into a situation where there might be some litigation involved and an opposing counsel asks me for the minutes that reflect that the board actually did what it was supposed to do, then we would have that. We would have those meeting minutes available for you. So this information could also potentially be considered in executive session. And part of the reason for that is because we don't want to breach the privacy of individual owners or violate any privilege. These are all things that come from that statute as well. We also don't want to disclose any information that was supposed to be confidential at the request of the affected parties. So if it's going to be considered an executive session, that can be done. However, after the executive session has adjourned, you have to make sure that the association's board comes back and summarizes orally what was done during the executive session. It should be a summary. It does not need to be a full out explanation of what was done, because remember, that's information that was considered during executive session, and then it needs to be placed in the meeting minutes. So everybody keep that in mind as you're going through your open board meetings. And then as we're kind of proceeding through this presentation, this is kind of one of the first steps that needs to take place before it gets turned over to the association's attorney. So once a file gets turned over to an association's attorney, and right here, we are going to focus on single family communities or those that are from Chapter 209. What does RMWBH do with that file? So we get an email that says, here's a new file for you guys to take and run with, right? Once we get a file in our office, we're going to go through our setup process, and there are certain searches that we'll do. One of the searches is a bankruptcy search to ensure that the homeowner hasn't filed bankruptcy, because we don't want to violate any automatic stays. And another thing that we'll do is kind of look at, the title of the property and make sure that the person that the 209 letter went to is the appropriate person or the actual property owner itself. And the property owner is going to be reflected on the deed that's been recorded in the real property records. After we've gotten that done and we don't find any issues with the information that's been turned over, then we will go through our process and we'll send that validation of debt demand letter. That information is required by us or by Regulation F or by the Federal Debt Collection Practices Act. And that's a 45-day letter. So we have to give an owner this sort of notice and give them 45 days to respond. There are certain requirements that go into that letter that I won't get into because it's not required to be sent by the managers, but that is something that we have to send internally, and we're required by law to do that. There's also a lien notice letter that we can send as well. So if the association has the authority to record a lien in the real property records and they have not done that earlier on in their process, then the association's attorney can actually do that for them as well. But that letter requires certain notices as well. So we would send out that letter if we were going to actually file a lien in the real property records. In addition to that, during our process, we're going to look in the what we call a nothing further certificate, or it's kind of like a title search, to find out if there are any lien holders for the property. Now, there are some associations that might require us to send lien holder notice to a superior lien holder, or like a mortgage company or something like that. But in general, we do have to send out notice to an inferior lien holder to let them know that we're about to begin with foreclosure proceeding. And so that kind of alerts them that if they want to, step in and exercise whatever rights that they might have as an inferior lien holder, then they can do that. That letter requires 61 days notice. So keep in mind that that 61-day time period is only relevant if there is actually an inferior lien holder. If there isn't, then perhaps that letter doesn't get sent out. Now, I mentioned Regulation F and the FDCPA. There are certain things that we cannot do as a debt collector under the FDCPA. And some of those things are related to communications with the owner. So now, since that Regulation F was enacted, an owner can opt out of communication with a debt collection agency. There's also a 7-and-7 rule, which means that the debt collection agency can't contact that owner more than 7 times, or more than within 7 days. Like after the 8th day, they have to kind of give it a rest, right? So these are just a couple of things that we have to take into consideration. That's not really for you guys, but it's just so you kind of understand what we're contending with as far as the regulations that are put on debt collection agencies. After we've gone through this workflow, this is our pre-litigation workflow, then we get to the stage where we would reach out to the association and ask them, do they want to file a lawsuit? And that conversation would kind of look like, hey, we have, completed our workflow. We have not gotten any response from the homeowner. Does the board want us to proceed with our lawsuit? We might also at that time ask if the board wants us to proceed all the way through the foreclosure process. But there are definitely certain touch points that we would come back to the board and say, hey, listen, here's an update on what's going on. The lawsuit has gotten to this point. We've obtained a judgment. Maybe do you guys want us to proceed with foreclosure? That's an individual conversation between the attorney and the board, but this is what it looks like generally for our pre-litigation process. All right, so we are going through the pre-litigation process, right? I've just kind of set up what we do, what our workflow looks like internally. And so it's also very important for us to kind of look at some of the pitfalls that we can come across, or some of the issues we might have during that pre-litigation process. And some of these apply throughout the entire time, but certainly during the pre-litigation process, we want to call your attention to these. So what are some of the complications that we can run into? Well, there is a defense, a legal defense that's called accord and satisfaction. And what that means is it occurs when parties agree to the discharge of an existing obligation in some manner that is other than what the terms of the original contract were. So in layman's terms, what that means is if the owner they owe $5,000 to the association, for example, but somehow the association agrees to accept a lesser amount, then that means that that $5,000 is no longer in play. So the association cannot try and collect the $5,000 anymore. They have accepted, whether on accident or on purpose, that lesser amount. Maybe they've accepted $2,500. So then that means that the owner later on, if the association is attempting to collect the $5,000, can go back and say, I've already submitted this $2,500 payment, for example. You guys accepted it. The check was cashed. It was, deposited into the association's account. I'm no longer responsible for the amount that you're trying to collect. That's a legal defense. And so that's something that we have to kind of keep in mind when we're dealing with collections, right? Because we've gotten to a point in society where the homeowners are a little bit more crafty than they used to be. And so sometimes they will try to submit a lesser payment. And this is one of the reasons why you've probably heard us say we don't want to accept partial payments, because it gets us into a situation where this could be a successful defense, right? If a homeowner has submitted something that's less than and we accept it, then the owner is no longer on the hook. Some other collection pitfalls can look like, we were just talking about accord and satisfaction. What do we do if we have a payment and we're trying to make a decision about whether we keep or return this partial payment? Well, there are some factors that we want to look at, right? We kind of look at the timing of the payment, how how much was the partial payment, right? How much did the owner pay? So if we're going to go back to that $5,000 example, did the owner pay $100 or did they pay $4,950, right? We probably wouldn't recommend returning a payment that was $4,950 if the amount that was delinquent was $5,000. But there are a lot of factors that we want to consider, and we wouldn't just want to accept a payment, without considering all of these factors. And we also want to look at, and this is very important, application of payment statute, which I'll talk about in a few minutes, because that can really change. It kind of makes or breaks what our decision is going to be as far as accepting a partial payment or rejecting it. We also want to look at things like limiting instructions or a restrictive endorsement. What does this mean? Well, if you have gotten a payment from a homeowner by check, for example, and the homeowner writes on that check that the check itself is supposed to be for the 2025 assessments only, but they owe assessments back to 2022, for example. Well, in that case, the owner has put a limiting instruction on that check. And if that check actually gets cashed, then the association is then put in a situation where they have to apply that payment according to what the limiting instruction on that check looks like. So that is another pitfall or partial payment, because it kind of throws things out of whack as far as what that account history, what that delinquency, what the ledger looks like, right? It also kind of changes what the priority of payments would look like for the association as well. So be wary of any statement that's written on a check or any payment that's made by a homeowner, because that could kind of get the association into trouble when it comes time, in terms of collection. And if you accept that payment, it could equal payment in full. It could go towards a court in satisfaction defense. It just kind of makes things a big mess for the association, and we don't want those sorts of things to happen. Another thing we want to kind of look at is if the owner is on a payment plan and they have defaulted in some way, and then they come back and try to make a payment with those limiting instructions, that would change the nature of the payment plan. So let's say, for example, they've made 3 payments on the payment plan, they've missed payments 5, 6, and 7, and now we're on month 7 or month 8 where they should be making a payment. If they write some sort of limiting instruction that says that this is supposed to be month 4 payment, but now there's interest that has accrued, there are other fees that have come about because we've had to send out a letter letting them know that they've defaulted. These are all just things that we want to kind of keep in mind when it comes to partial payments. And so generally, our recommendation would be do not accept a partial payment unless, of course, the homeowner is on a payment plan and the partial payment represents one of the payments on the payment plan, right? That would be a completely different story. So just pay attention to that. A couple of minutes ago, I mentioned the priority of payment statute. So you guys are probably all familiar with this too. It's section 209.0063. And it tells the association how it must apply payments that are received from the owner on a delinquent account, right? So why is this important? Well, the statute lets us know that we have to apply payments that we receive on a delinquent account to the delinquent assessments first, and then to the current assessments. And then you can apply it to attorney's fees. You can see that fines and other amounts that are owed to the association are further down that list. Well, if a homeowner makes a partial payment, and let's say, for example, they have gone and done some research or they've chat GPT'd, what they should do if they become delinquent on their assessments, and they try to make a payment that only equals to the delinquent and the current assessments, and they leave the attorney's fees or they leave the fines or whatever else on their account, then that makes it very difficult for collection purposes. And in fact, the association we can't file suit, even if the association wants us to proceed with going all the way through the lawsuit stage and go into foreclosure. The attorney's office cannot file suit on an account that does not have any delinquent or current assessments or any past due assessments, right? It cannot be filed just on fines alone, and it shouldn't be filed on attorney's fees alone. Courts look very badly upon that. They do not like the idea that you've charged attorney's fees or fines to a homeowner's account and that they've paid all their assessments, and now you're adding more attorney's fees onto their account for going through the litigation process. So that's why we have to be careful again about accepting partial payments, because they have to go to those assessments first, and it kind of takes away the leverage the association might have in a lawsuit, right? There's a caveat to that, though, that if there is a payment plan that was in place with that homeowner and they have become delinquent on that payment plan or alternative payment schedule, as the statute refers to it, then the association doesn't have to apply payments according to the priority of payment statute, if that makes sense. Regardless to that, though, we cannot apply any payments that are made to fines first. That's simply not allowed by the statute. Now, condos don't have that same requirement, priority of payments, unless, of course, there is some priority of payment that's been detailed in their declaration. And so our recommendation would be to adopt a priority of payment policy so that everyone understands how payments made would be applied, right? Because there is no statute that mirrors this one for Chapter 82. All right, so we've talked about Chapter 209 and what that collection looks like. What are the relevant statutes for collection? Let's look at condominiums for a second. And the statute that we're going to focus on here is 82.113, because that kind of gives us all the information that we need as far as what the lien looks like, what assessment collection should look like, and what authority the association or condo association would have under the property code. Now, with everything that I'm saying, you should also keep in mind that there are various statutes in the property code, but the declaration and any associated policies or anything like that are also a really good place to go and look to kind of determine what the association or what process they need to follow for collection. 9 times out of 10, it's going to mirror what's in 82.113, but if there are any caveats or nuances that you should be aware of, you're going to find them in your declaration. So going back to Chapter 82.113, it talks about levying an assessment or filing a lien. This is very similar to what we've learned about single-family communities. The assessment is levied, and it's a personal obligation of the owner. That is it's secured by a continuing lien on the unit and whatever rents and insurance proceeds that might be received by a unit owner. That all happens when the declaration gets recorded. Most times the declaration is recorded before a building even starts developing or before it gets built. And so that means that lien is placed on the unit for condominiums or on the property for single family homes before a structure is even built there. And this is the same for single family as it is for condominiums. There is a continuing lien on that property or on that unit, and it goes throughout the duration and kind of in perpetuity for that lien, for that unit or that property. So what does this mean for condos? Well, that means that regular and special assessments, any dues, fees, charges, anything like that, anything that's listed there in that first bullet point, those are all things that are secured by the association's lien on the unit. In addition to that, there might be any other amounts that might be owed to the association by the unit owner or levied against the unit by the association. So generally, any amounts, right, that might be owed to the association that are secure, that are mentioned here in the statute or mentioned in the declaration, they are secured by a lien on the unit, and those amounts are owed to the property, and that's what gives the association the authority to foreclose, which is something I'll talk about in a second. Another important section of 82.113 is subsection B. And so this goes into a little bit more detail about the association's lien and what priority it has over what other liens that could be potentially be levied against a unit, right? So the association's lien has priority over every other lien except for the ones listed here, right? So a lien for property taxes takes priority over the association's lien. A lien that was recorded before the declaration was recorded, that would take any sort of precedence over the association's lien. And then a first deed of trust lien, which is basically a mortgage lien, also has a priority over the association's lien. So these are the three that are listed in the real property or in the property code. And there generally aren't any other liens that have priority over the association's lien. Earlier, I mentioned junior lien holder notice. And so any other lien would be considered junior lien holders, and they do not have priority over the association's lien. So that's why the association can go and foreclose on a property. And those ones that have priority, the association's lien being foreclosed doesn't extinguish those liens. But the other way around, a first deed of trust, for example, extinguishes the association's lien, if that makes sense. So it's kind of nuanced, a little bit crazy. And so if these kinds of situations come up, it's always good for you to consult the association's attorney to get some additional information about how the priority of lien situation kind of works. If there's a foreclosure coming up or whatever, what would happen to the association's lien? Would it be able to stand up against this foreclosure, or does it get extinguished by the foreclosure? All right, so when we acquire a unit in a condo, you are granting the association the authority to sell the property at a foreclosure. So this is called the power of sale. And that is a right that's given to the association connected with their authority or that lien that they have, right? And so an association has that power of sale through section 51.002 of the Texas Property Code. That power of sale is not only granted to condominiums, but also to single family associations. And so both of those associations would look back to section 51.002 to get this requirement for power of sale, or to see how that power of sale actually would play out for those individual communities. Now, for condos, it's a little bit different because they have a power of sale, but it's generally what we refer to as a non-judicial foreclosure. So we're back in section 82.113 again, but now we're looking at subsection E, and it tells us that the association has the right to foreclose judicially or non-judicially. But typically, since a condo association has that non-judicial foreclosure power, then we would go ahead and follow that procedure when it comes to foreclosure for condo units, right? Now, of course, we're talking about a delinquency that consists of assessments and other amounts, because as I mentioned before, we cannot foreclose on a lien that consists of only fines, right? That's the same thing that I mentioned. You can't file a lawsuit when the delinquency consists of only fines. The Chapter 82 makes it pretty clear that you can't foreclose on a lien that's only consisting of fines, right? Now, this is a little bit different from Chapter 82 foreclosures, or Chapter 209 foreclosures, but for condominiums, the cost of foreclosure can be added to the amount owed by the unit owner. And so that can also be included in the amount that you call the non-judicial sale for. Now, a unit owner can't come back and say, like, after that sale is over, right? The foreclosure sale has gone and a unit has been sold at auction. A unit owner can't come back and file a lawsuit or file a request to set aside the foreclosure because the purchase price at the sale was lower than what the debt amount is. So that is a legal action that's kind of taken away from an owner, because the auctions are unpredictable. We never know how much they're going to go for, or if someone is going to come forward and attempt to purchase the unit at all. So the property code kind of makes it, takes that out. A unit owner can potentially, try to get the sale set aside for other reasons, but it certainly cannot say that they didn't get enough money from the sale or there were no excess proceeds or anything from the sale. So that's actually a protection for the association. I see a lot of questions at the end. I think I'm going to have time for questions, so I will come back and try to address as many of them as I can. All right, so what happens if a condo unit owner defaults on, paying their assessments, right? Well, if the unit owner defaults and they have, not paid a certain amount of assessments, and this is kind of a discretionary thing too, right? Because some condos may have an annual assessment, some of them may have a monthly assessment. And so really, you should justify pushing things to foreclosure based on the amount that the homeowner owes, right? So I wouldn't recommend attempting to do a non-judicial foreclosure for 1 month delinquency and assessments. But you also don't want to let the amount get too high either. So this is a discretionary thing for the board to kind of look at. But if there is a default, then the association can notify other lien holders of the default and let the other lien holders know that the association intends to foreclose. So this is kind of what I was mentioning earlier with that notice of intent to foreclose to other lien holders, junior lien holders, and even senior lien holders in some instances. Now, this does not prohibit the association from taking a deed in lieu of foreclosure. A deed in lieu of foreclosure is essentially the association taking on ownership of the unit instead of them foreclosing. So, that is kind of a fancy way of saying they just ask the homeowner, or not necessarily, but the homeowner has the ability to transfer interest in that unit to the association, and then the association would take on the ownership responsibilities for the unit. The association still can recover, or they can file a lawsuit to recover a money judgment. A money judgment's a little bit different than a personal judgment. A personal judgment is against the person. It kind of follows the person around. A money judgment is just for the sum of money that you're seeking to recover. And so this part of the statute tells us that the association has the authority to seek a money judgment that for amounts that might be secured by the lien. And then, obviously this is could be considered an obvious thing to say, but the statute is also pretty clear that a unit owner has the ability to come in and pay all of the amounts that are due to the association to avoid a foreclosure sale at any time before that foreclosure or before that sale is actually called. So really this means if the sale is supposed to be called at 10 o'clock, a homeowner could come in at 9:59 a.m. and pay all the amounts that are owed, and we would have to cancel the sale. All right, so I've mentioned what our pre-litigation process looks like for Chapter 209 properties. And it's going to look a little bit different for Chapter 82 properties because in general, we are not filing lawsuit. Generally, what we're doing is a non-judicial foreclosure. And so once we get an account from a condo association, we perform the same searches that we would do, or do the kind of same setup that we would do for a Chapter 209 property. We're going to look at the deed. We're going to look at account histories. We're going to look at, the demand letters that the association has sent to ensure that it meets all of the requirements of the property code. We'll also look at bankruptcy searches. And as I mentioned before, the reason why we're looking at the deed is to make sure that the owner is the same person that we've sent our demand letter to, right? In addition to that, we're going to look at ledgers or account histories, and we're going to analyze those. We're going to look at the amount of delinquency. We'll look at whether or not there are any amounts that might be barred from collection by the statute of limitations. We'll look at interest, and we'll make sure that the association has the authority to actually incur interest on those delinquencies. Sometimes there is no authority for that in the declaration, and sometimes the declaration says that it might be secured by the lien, and sometimes it doesn't. So we need to go in and kind of look at that information too. And then we will, after we've done all of those analysis and all those searches, we're going to send out our Regulation F validation notice. At the same time, or shortly after that notice has expired, because this is also a 45-day notice, we are going to request approval from the association to send a demand letter. There are a lot more touch points with condo associations because we want to make sure that we're getting that approval from them to go through these various steps of the collection process. And since there is no lawsuit that's going to ultimately be filed, we want to just make sure that the association is comfortable with exercising their authority to send us through that process, right? Turning over that account, sending a demand letter, and then ultimately going through the non-judicial foreclosure. And so once we've gotten the approval to send our demand letter, and again, just think about the demand letter is different than the Regulation F letter. And all of these letters are giving several opportunities to homeowners for them to actually pay the assessments that are past due and attorney's fees that have incurred. And just a point about, how many attempts that we make and how many times we send out letters. Once we get to a stage where we might have to file a lawsuit, and of course this is for single family communities only, a court likes to know that we have made all of the effort that we can or exhausted all of our efforts to reach out to a homeowner within what we're supposed to do according to the statute to make sure that the homeowner is aware of the fact that they owe this money and that they are aware of the fact that the association has the ability to foreclose and that they might ultimately lose their home if they don't pay some attention to the letters that we're trying to send out, right? So that's why it's so important to get these letters out and give these different opportunities for a homeowner to get the information, one, get notice, and then two, for them to respond. So that's just kind of a little soapbox that I like to get on about making sure that we send out all of these demand letters. But in a condo context, once we've gotten the authority to send a demand letter out, we're going to look at our title report. Again, we're going to make sure that title has not changed hands at all. And then we're also in that title report getting the lien holder information to see if there are any lien holders. We're going to review those. If there's a lien that's been filed in the real property records, we're going to take a look at that too. We also do tax searches to just kind of see if there are any delinquencies with the taxing authority, just to kind of see where we are and keep a pulse on whether or not there might be an incoming foreclosure by the taxing authority as well. We will also prepare an appointment of agent for sale. So that is a document that we have to get from our clients that gives the attorney the authority to call a sale during a foreclosure sale. So the association has to give us authority to do that, and we get a signed document that later gets recorded in the real property records as well. Then we go through the process of sending out our notice of sale, making sure that the constable does whatever the constable needs to do in order to post that the sale is going to take place, and letting the homeowner know the date of the foreclosure sale. And again, giving them another opportunity to kind of come forward and put a stop to all of this by making a payment or by setting up some sort of payment arrangement so that the foreclosure sale doesn't actually happen. And then finally, one of our attorneys will go down to Harris or Brazoria or Fort Bend County and attend the sale. And more likely than not, we are actually calling the sale as well. And during that time, it's kind of like an auction is taking place. And we are, observing any persons that are bidding on the property and then taking down those final notes as to who is the person that has won the auction if anyone bids on it, and even collecting the funds if there is a sale that takes place. So that's kind of our process after we've gotten the approval to send out the demand letter. Now, if we have gotten to the stage of foreclosure, either a judicial foreclosure, which means we've gone through the court process and we've gotten a judgment that allows for us to foreclose, or we have done a non-judicial foreclosure for a condominium, the property code authorizes a right of redemption for properties in both contexts. So with a Chapter 209 property, after the foreclosure sale, we give notice to a homeowner that the sale took place and that the property was sold. That has to go to the owner within 30 days of the sale. So then the owner then has 180 days from the date that's on the notice to redeem the property. Now, there are a couple of instances where they could redeem the property. They either redeem it from the association if there were no bidders, or they have to redeem it from a bidder, a third-party purchaser. In any case, all of the amounts that are owed to the association have to be paid. If a third-party purchaser pays it, then the homeowner has to, or the prior homeowner has to pay the third-party purchaser and the association. And then they have to pay for all the costs that were incurred during the redemption period. There are options for other lien holders to step in too, but they have to wait at least 91 days before they can actually step in to redeem the property. And then they can do that between that 91 and 180 day mark. Now, as far as Chapter 82 properties are concerned, after the non-judicial foreclosure sale has taken place, the procedures are similar, but the deadlines are a little bit different. So instead of 180 days, they have 90 days to redeem the property. So 90 days from the date of the notice, which, 3 months, they can come back in and redeem the property. And at any point they want to do that, they, can just contact the person who actually handled the sale, which is our office, and we can, help them work through redeeming the property. There's also an option for owners to try to extend that redemption property by agreement of the association. But 180 days, even 90 days is such a long period of time that it would be up to the association to their discretion to actually do that if that's something that they wanted to do. All right, so a lot of times when we are taking on new clients or new associations, they're looking for a timeline of when these things can get done. So first we'll talk about single family, and then the days are going to be a little bit different for a Chapter 82 condominium association. So we'll go through this first. I have already kind of talked about what the attorney workflow looks like. And so here are the dates that are kind of associated with that. So on day one, let's say that's the date that we get a new file that's turned over to us. Between days 2 and 7, we're going to get that account set up. We're going to run those searches that I was mentioning before, deed and bankruptcy searches. And then we're going to get the ledger or the account history that we've received from the association. We're going to get that inputted into our software. On days 3 and 8, after we've gotten everything set up, that's when our Regulation F notices will go out. So this notice provides 40 to 45 days for an owner to remit payment or enter a payment plan. After that, after the expiration of that letter, then we will do what's called an NFC search. That is a nothing further certificate that gets completed by our title department and then reviewed by the attorney that is assigned to that association. Once the attorney has reviewed that and determined whether or not there needs to be any lien holder notice sent out, so when we're looking at NFCs, we're looking for junior and senior lien holders. We're looking to make sure that there has been no change in ownership for the homeowner. We're also looking for things like divorces that might have awarded ownership to a different party. We're looking for any deaths that might be related to the property owners. And if that's the case, maybe a probate that has been filed or that might be ongoing or anything like that. So the NFC report is going to tell us a lot of information about the property. After that has taken place, then it's time for us to either file the lien or send out the lien holder notice. An owner has 30 days to remit payment from a just regular demand letter if it's not a lien holder notice, and then 61 days to remit payment if there is a lien holder notice. And then finally, after the expiration of the letters, the respective letters that we might have to send out, then we're going to make a request to file a lawsuit to the board. Now, this timeline is taking into account that we have not received any response from a homeowner. There are no issues with the file that's been sent over to our office, that we haven't found anything out of the ordinary on the NFC or any of the searches that we have done. And so this is just the approximation of a perfect file that gets sent over to us and what it should take, how much time it should take for that file to make it to the stage where we can request authorization to file a lawsuit. Now I'm going to tell you what the collection timeline looks like for condos. It's very similar, but there are a couple of differences that you'll see in the later time periods, right? So again, once that file gets referred over to us, that's day 1. Days 2 through 7, we're going to get that account set up and we'll do those searches. We'll make sure that the ledger gets input, and we're doing an analysis of the ledger again that I mentioned earlier. We're looking at interest. We're making sure that interest is being charged properly. We're looking at, how the assessment is being charged. Is it annually? Is it quarterly? Is it monthly? Those sorts of things, right? After that, all of those things take place. And for example, we have not found anything out of the ordinary. And one of the things that we could find out of the ordinary here is we look at a deed and we notice that the name of the person on the deed is not the same name as the 209 letter, for example, or the demand letter, for example. Then we might kick that account back out to the manager or to the association and let them know that they need to send a new 209 letter to a homeowner, and to the homeowner whose name is actually on the deed, right? Moving on to the Regulation F debt validation notice. That notice is going to provide this time period for a homeowner to remit payment or to enter a payment plan. If that doesn't happen, during days 58 through 60, we're going to get that NFC report by our title department and then have the attorney review it. And again, we're looking for those things like changing of hands of the property, bankruptcies filed, deaths, divorces, that sort of thing. Then on day 60, we can get a lien filed. And if there's a lien filed, then a homeowner has 30 days to remit payment. Because again, if you recall, we're going to send out a notice to the homeowner to let them know that that lien has been filed. And then on day 90, we can request authority from the association to post the property for foreclosure. And after we've gone through the process of making sure that we send proper notice to the homeowner, we request all of the things that we need to request from the constable, they post the sale for the required amount of time that they have to do it, then we can actually attend a foreclosure sale. So again, this timeline is taking into consideration that we have found no abnormalities in the file once it's sent over, that we didn't find anything, that needed to be adjusted in the deed, no extra work to, input the ledger or recalculate interest or anything like that, and that there has been no communication from a homeowner. We're just kind of sailing through the process. Now, the last thing I kind of wanted to talk a little bit about is RMWBH's true flat fee. So a lot of times when we are sending out our engagement letters, or we're being approached by an association for our firm to represent them, we let them know, listen, we are charging a true flat fee, and then they have questions about what that actually means. Well, here's what that means. And then this is something that can kind of help you guys too, if you're making recommendations for us or whatever the case may be, or if you have other questions about this, you guys can always reach out to us to ask those questions. But our firm charges one fee per litigation assessment collection service. So what that means is we're going to charge one fee for a demand letter. We are going to charge one fee for that Regulation F letter that I was talking about. We charge one fee for a lien holder notice, right? There are not going to be any extra charges for phone calls, emails, staff communications, or any other attorney conversations or actions, right? So that means if during that timeline that I mentioned in the previous two slides, a homeowner calls in and they want to make a payment, then the association is not getting charged for that phone call. The emails that might be going back and forth between homeowners, and emails are important because we like to make sure that we have communications from our homeowners in writing. So of course, there's going to be emails that kind of go back and forth when we do get communication from a homeowner. Those do not get charged to the association at all. So what we're saying here is that this is a true flat fee. The flat fees that you see in our engagement letters are the fees for the service, and it includes all of the things that we kind of talked about, like those searches and that sort of thing. It includes phone calls, emails, conversations, attorney actions, and that sort of thing. So generally, unless something has gone completely off the rails, you will not see other charges on the invoices that we send out for the things that I just mentioned here. Now, this actually provides a significant attorney's fee savings when it is compared to other POA law firms, because while you might see a flat fee for other things that they might be doing, you would also see charges for phone calls, emails, and staff conversations. And as we all know, those sorts of things can really add up. They can really pile up, especially if there is a homeowner who has a bunch of questions, or there's a lot of back and forth about a payment agreement or something of that sort. And then the last thing to kind of keep in mind is the flat fee for pre-litigation assessment collection is going to apply to all community associations and developments across the board. So in this presentation, we've talked about 209 and 82 communities, and those are the ones that you probably see most often. But if there's a mixed-use community or a townhome association, a huge master planned association, a commercial association, or anything like that, all of our flat fees in our pre-litigation collection workflow are going to apply to all of those community associations across the board. And so you won't have to worry about some sort of like surcharge or whatever for a townhome association, because it's a little bit different. So that is the gist of the RMWBH true flat fee. But if there are questions about that later on, you guys can feel free to reach out to me and I can answer those questions. All right, so to conclude, we want to make sure that all of these rules that I've talked about, we want to follow those closely. We don't expect for you all to know everything or have all of the answers, but that's why we're here. You can consult the experts and come in and talk to us with any questions that you might have. And most of you guys probably have a copy of our POA code book, the ones that we publish here in-house. So we want to make sure that you guys have those. If you don't have a hard copy of it, then you can go to our website and pull up a copy of it, so you can actually go to the code and go to the different sections that we've talked about to get that information. And if it is confusing or if you have questions, don't hesitate to reach out to us. Also, it's really important to not wait to start collection action, because you could run into things like the statute of limitations, or just other issues might come up if you wait too long. There are defenses that can be raised that, the association waived their authority to enforce, or they abandoned their authority to enforce. And those are things that we don't want to have to explain to a judge if we don't have to. Go ahead and initiate that collection action, at the appropriate time, so that we can get the ball rolling on that. And then finally, trust the attorney to clear up any confusion. I've said this a couple of times, but if you have questions about what the association should be doing, then make sure that you consult the association's attorney. And Kyle, I just saw a question about if we can provide a link to the property code books. Can you put that in the chat for me, please? All right, so that is our presentation for today. Just one final thing, if you guys are so inclined, scan this QR code and leave us a Google review. It helps us to improve our services because we can see, any pros and cons or, good and bad things that you guys might have to say. And it's also a really good way to showcase potential clients of, what our legal services kind of look like and the things that you guys have come to trust, that they can expect that same thing from us if they so choose to decide to go with us. So thank you guys so much. Let me go to the questions and see if I can get to a couple of the questions. We have about 10 minutes. So yes, about these slides. All right, does the open board meeting apply to a declarant board? The answer to that is yes. Open board meetings, it is a thing that doesn't only apply to community associations. There's an Open Board Meeting Act. So if the association is, even if it's under declarant control, they still need to have open board meetings. Approval of statute of limitations need to be approved in an open board meeting. I'm not sure I understand this question because the statute of limitations cannot be collected. So the statute of limitations in Texas for collection of assessments is 4 years. So that means that anything that was accrued outside of that 4-year statute of limitations cannot be collected by a collection agency. We cannot file a lawsuit on anything that is outside of the statute of limitations. Whether the association can enter into an agreement with the homeowner to pay things that were accrued outside of the statute of limitations is a completely different thing, but we cannot do that. So if you approve the enforcement of a collection enforcement action and you send it over to us, then we will only be able to collect things that are within that 4 years. I hope that answers that question. All right, open board meeting does apply to the declarant board. So they still need to make those decisions that are covered by 209.0051 during an open board meeting. The agenda does not need to have specific language. So what we recommend is the agenda it should say something like the board is going to consider and vote on collection enforcement action or even deed restriction enforcement action. And that's as specific as you need to get. But then when you get to your minutes, right, I'm sure you've been on presentations where we've said the minutes need to be a very brief, maybe bullet point summary of things that occurred during the meeting and not like a, 12-page dissertation. And so what you can say in your meeting minutes after, at the close of the meeting is just that the board considered and voted on collection enforcement or deed restriction enforcement, and that really can be it. A lot of times associations will include some sort of indication of what accounts were considered, but if you're doing that, you have to make it so that it's not easily referred back to the actual homeowner, right? Because we cannot share personal or deed restriction or any sort of violation history of a homeowner, and you don't want to give out confidential information about a homeowner and their delinquency status. So if you're going to include that, then it needs to be done by something that's only identifiable by maybe the board and the manager. Recording of this meeting, Kyle can answer that question. So what do managers of heavily military owners have to take to make sure we're not violating active military rights? So this is a very good question. So part of the reason why Chapter 209 has that requirement that you let homeowners know that they might have some relief under the Civil Service Members Relief Act is because that is a military requirement, right? So you guys can send out letters or 209 letters or demand letters to homeowners who might be in the military, and we could even potentially file lawsuits against them once we've gone through the collection process, but we are not allowed to take a default judgment against a homeowner who is active duty. So that is a whole nother, situation that we can get into a little bit more in depth later on if you want to reach out to me, Joseph. But that is the general answer to that question. All right. Are the property codes you were showing standard in the industry? Yeah. So the property code sections that I went through today during my presentation can all be found in the Texas Property Code. And as I mentioned, our property code book kind of outlines and puts all of them there in black and white for you guys to be able to easily reference. So if you need a copy of our property code book, just let me know and we can try to send you a copy. Otherwise, there's a digital version online, and hopefully Kyle has already copy and pasted the link so you guys can get a hold of it. Can a management company charge a monthly fee to owners that have a delinquent balance? There are some management companies that I know that are charging a fee for kind of monitoring a delinquent account, but it really all takes into consideration what is in your management agreement. So whatever agreement that you have with the association is really going to determine what you're able to charge. If a member auto pays their account, if you have a member that is delinquent and they're still on auto pay, I recommend that whatever software that you're using, you go in there and switch that off so that they can't make those auto payments. Or you need to there needs to be a delinquency status that's set on there somehow so that the owner can't continue to just make those auto payments. But that's also why it's important for you to have a priority of payment statute, or if it's a 209 community, to kind of look at those priority of payments, because that can really alter delinquency status, right? So that's something to kind of keep in mind. How can the association assure that violation fines are paid if the resident decides to only pay assessments? Don't accept partial payments. So if an owner is paying you an amount that's only equal to the amount of delinquent assessments, don't accept it. Where do you find the codes? They're in the Texas Property Code. Someone's asking me to touch on money judgment again. So a money judgment is a judgment that you can obtain that is not against a person necessarily, but it's just for the amount of money that's owed to the association. And there are different ways to actually execute on that judgment that would, try to get money from a homeowner. But we also like to recommend getting that personal judgment because it actually has a little bit more teeth than something just like a money judgment does. Who notifies other holders? So we will notify, if you turn an account over to us, we notify all of the appropriate lien holders. There might be some other lien holders that the property code does not require us to give notice to, but we will notify all of the lien holders that are appropriate according to the statute that we are able to locate through our searches. Can the condo association foreclose for only fees added for exterior repairs that are in dispute? It depends on whether or not the declaration says that those fees are secured by the association's lien and can be collected in the same way that assessments can. The next question, and this might be the last one depending on what it says if the owner shows up at the last minute to pay what is owed, does this include all legal fees as well? Meaning the HOA is not going to receive another invoice. That's not necessarily the case. So for Chapter 209 properties, the association can only foreclose on the amount that's in the judgment. That does not mean that there might not be some other amounts that are accrued after the judgment amount. And so it's possible that a homeowner can come in and pay the judgment amount, and there might still be outstanding amounts after that because there were fees incurred for actually posting the property for sale. When it comes to condominiums, the association or we can actually include all of the amounts, all of the costs and legal fees that were incurred for up to the time of the sale, including for posting and everything. And those can all be included in the foreclosure sale, or that can be included as the amount that the association is going to foreclose on. Can associations charge a late fee before sending a 209 letter? Technically, yes, but we also need to look at what's in Chapter 209, and it says before the association can levy a charge or a fee or anything, it has to give the homeowner the opportunity to be heard. So essentially sending out that 209 letter to let them know that they can request a hearing and giving them the opportunity to either cure a violation or pay the fines or fees. That letter needs to go out. So I wouldn't recommend putting any fees like that on there unless the 209 letter has expired. Is there a benefit to a condo judicial foreclosure versus a non-judicial? Non-judicial foreclosure is a lot cheaper and it's quicker to get to. So condos, we recommend doing non-judicial. And that is going to be the last question that I can get to. There's a couple more on here. And if you guys want to scan that QR code that's on the slide right now, you can probably find my email address. You can reach out to me via email and I'm happy to answer any other questions that you guys have. I really hope that this information was helpful for you today, everyone. And we appreciate you guys so much for joining us. Hopefully you will log on next time when we have our next webinar. So look out for all of the information that Kyle's going to send you about when we get that schedule. And then don't forget to submit a Google review if you have the chance. Thank you guys so much for spending your lunchtime with me. I'll see you next time. Bye.